So word constitutionalism is a popular word in polity, and UPSC can ask various dynamics of this concept. Therefore, we need to understand the basics of this word constitutionalism. So there is a written word, we can say it is a constitutionalism. Constitutionalism. There is use of word ISM. Whenever you see this word ISM, it means a philosophy. It means a philosophy. So constitutionalism is a philosophy. It's a philosophy regarding government with limited power. So government can have unlimited power like dictators, but government's power can be restricted by certain documents, certain norms, and that document, the best known document for this purpose is Constitution. So a limited government or a government's authority limited by Constitution, this philosophy is called constitutionalism. So constitutionalism is a philosophy according to which the government of a state has limited power, and that power is limited by or restricted by, controlled by, regulated by a document called Constitution. So here in this philosophy, when we say constitutionalism, in this philosophy, the constitution of a country limits power. Okay. So constitution is a document which is an organic document which governs how states should run. And constitutionalism is a philosophy. It also says how states should run with restriction on power of the organs of the government. Clear? Now, word constitutionalism can be used for different purposes. And there are researchers, scholars who identify various domains of constitutionalism. So in liberal government, constitutionalism can be different. In a communist government or one party dominance, the constitutionalism can be different. There is use of term economic constitutionalism. There is use of term global constitutionalism. So we will understand about the various dynamics of this constitutionalism. Before that, if it is asked that what are the markers, what are the features of a country following the philosophy called constitutionalism? What are the markers? What are the basic things? What are the features of a government where constitutionalism exists? So for constitutionalism, there can be certain features existing in a country. Let us list these features. For existence of constitutionalism, the features can be number one, there must be a constitution. Generally, constitution should be written document. There are countries like England where constitution is not written, but they have well established conventions according to which they govern. So even if unwritten constitutionalism is possible, like we are finding in case of England. So first requirement should be a constitution. It should be written in general, exceptionally unwritten possible. So constitution is the first requirement. Why? Because government should be governed or limited by whom? Who will limit the power of government? The constitution. Existence of constitution is not sufficient. Maybe constitution is giving unlimited power to governments. It happened when in Russia, the Lenin's government was formed, Bolshevik Revolution, 1917. Bolshevik party, the Communist Party government was formed. So they drafted a constitution which given almost all power to the party leader, Politburo. It is possible. So there should be second marker is rule of law. Second marker of constitutionalism is rule of law. What is this rule of law? There are various approaches to understand rule of law. Various thinkers and scholars have given their own perspectives of rule of law. But generally we follow A.V. Dicey, an English philosopher, English constitutional expert's idea concerning rule of law. That I will discuss in this lecture itself. Okay. The second requirement is rule of law. Third requirement is for constitutionalism. Third requirement is a powerful and independent judiciary. Suppose there is a constitution existing and constitution is trying to restrict the power of the government, but government is trying to transgress those powers. Government is trying to sideline the constitutional provisions. Or there is well established rule of law existing, but government sometimes breaks those rule of law. In the hands of certain people, government grows dictator. A totalitarian system emerges. Then who will check? So there is a requirement, it's a must that an independent judiciary should be there to check the advances of the government. There are these three basic ideas existing. Apart from that, some supportive ideas also exist for constitutionalism. For example, separation of power. Separation of power, checks and balances, they are supportive ideas. They are not the primary requirements of constitutionalism. So a government restricted by certain documents or restricted power of the government not having unlimited power, this philosophy is constitutionalism. In India also we follow this concept, constitutionalism. So constitutionalism is in practice in almost all liberal democracies, even in India. It is said that the scholars like John Locke, Robert Merton, philosophers like A.V. Dicey, they suggested that there must be government's power restricted and constitution should restrict those power. Modern philosophers are credited with bringing the idea of constitutionalism. But it shall be wrong to conclude that this idea is a modern idea, because even the thinkers like Kautilya, if you study the references of Kautilya, Kautilya also talks about the king's restricted power. It is different that Kautilya had suggested more moral norms to restrict king's power. Like Kautilya says, in the happiness of the subject is the happiness of the king, and in their welfare is welfare. This is a moral norms, a moral philosophy Kautilya suggested to restrict the power of the king. But Kautilya also said, he is saying that kings should codify law. King's words were law. Those days, words of the king was law. But Kautilya said no, there must be codified law. If king is codifying law, writing law in the law book, then king will be bound to follow the written laws. So it will restrict the king's power itself. So Kautilya, like philosopher, is also suggesting about restricting the power of the king. As early as the 4th century BC, Kautilya, or 3rd century BC, you can say, mature period of Kautilya, you can say he is talking about restriction of the power of the king. Although the idea came into practice very late in the modern era, especially after the Second World War, the idea grew and it gripped the whole of the world. today world, most of the countries are following the philosophy of constitutionalism, some more, some less. Like in the communist governments, the constitutionalism is less practiced. There are dictatorial government in the country, monarchy also exists in some parts of the world, and the limited execution of the idea of constitutionalism is there. So this is the concept of constitutionalism. Definitely the related idea rule of law I will be discussing separately after I discuss some other concepts related to constitutionalism. So there is one more word, very significant word related to constitutionalism. We can call it the global constitutionalism. What is this global constitutionalism? If this question comes anywhere, what way this question can be asked, I will share about this. So what is global constitutionalism? Let me explain this concept. Concept of global constitutionalism. Okay. So you have heard about the United Nations Charter, no? There is word, sorry, there is word global constitutionalism. So definitely it's a philosophy. Ism means philosophy, and constitutionalism is a philosophy that the power of the state, power of the government should be restricted, limited. Now, global, when word global used as a prefix, global constitutionalism means that the government of the state restricted by some global law, global constitution. So it used to happen like if you look back to Europe, France was a country under Napoleon. France dominated almost all parts of Western Europe. France influenced the polity of Spain, Portugal, various parts of German Confederacy, Sardinia, Piedmont or other Italian states. It had great influence in Netherlands, Austria, indirectly, Austria also. So Napoleon tried to capture power. Napoleon had grown unlimited in power. Again, when Germany got united, unification of Germany 1870, Germany became so powerful that it tried to influence the governance of other parts of the world. Germans indirect influence through Austria in Serbia, Bosnia, Herzegovina, Albania, other nations, Croatia, etc. led towards First World War. Under Hitler also Germany grew very powerful. Under Lenin, Russia grew very powerful, and the Russia started creating satellite states. Even America was trying to bully the weak nations through its economic support or some modern support system which America could give to other parts of the world. America was more oriented towards diplomacy to utilize his status to dominate other countries. So it is possible that one country of the world is trying to dominate other country. It happened in the past. So there must be some global law, there must be some global norms which restrict the power of the governments. And that idea of League of Nations first introduced by Woodrow Wilson, and then came the concept of United Nations. So United Nations related, UN's related charter, conventions, agreements or obligations, are they binding upon states? Is it binding upon India? Is it binding upon Germany? Is it binding upon China? Binding upon US or other countries who are part of UN? Yeah, it's binding. Government cannot pass, Indian government cannot pass a law which is transgressing or which is violating UN's charter in which India is a signatory. If India is a signatory to that charter, India cannot bring a law against that UN charter. That means Indian government's power limited, restricted, controlled by UN Charter, UN law. And UN law is what? It's a global law. Similarly, concept of WTO, emergence of concept of WTO concerning free trade, agreement. Those who are signatory to WTO, they are bound to open their markets for other parts of the world. The countries cannot restrict the import, export, etc. into a nation or from a nation. They can't restrict. India signed WTO 1994, and almost all goods, some restricted areas are there, almost all goods and services now free in terms of trade. So this is also a global law. WTO is a global norms, global law. Then global law or norms is restricting the power of Indian government, Indian state. So use of word global constitutionalism, a philosophy that countries' power should be restricted by some global law. And beyond UN and WTO, there may be some regional agreements also of global nature, G20 related, G77. So there may be universal laws beyond UN which countries can accept, countries can become part of that. When they are part of that treaty or agreement, the countries are bound to follow those norms and law, and it will hamper, it will restrict the power of the government, it will limit the power of the government to do arbitrarily everything. So constitutionalism restricting power, global constitutionalism, some global law restricting power of the government. Now, how this concept is related to or relevant in context of our study, or how UPSC can ask the question. Let me interrelate this part here. There is a, if you read preamble to Indian Constitution, so in the preamble there is a use of term sovereign, no? If you can recall the preamble's words, preamble says, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political, so and so." So, we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. There is use of word sovereign here, no? Is it word sovereign? What is sovereign? What do you mean by sovereign? Sovereign means power of its own. Means a country not restricted by other country not limited by other nations. Country can pass any law, can fight war against any country, can have peace treaty with any nation. That is sovereignty. India is a sovereign country. Is it true or wrong? Yes, India is a sovereign country. So India is a sovereign country, but India is restricted by WTO. India is restricted by UN. Now India cannot disallow import from America, can't restrict. Or India cannot restrict export of most of the goods and services. India can't restrict them. Or India is bound to follow UN's norm, UN's charters in various matters. So there is word sovereign, but India is restricted by UN law, UN charter, UN convention, UN agreements. India is a sovereign country, but India is limited by the norms and laws of the WTO. So here in this context there can be a logical questions. So can you say that Indian sovereignty, the word sovereign, is becoming less relevant in the context of constitutional provisions of the world, or the idea of global constitutionalism, world constitutionalism? The word sovereign is reducing its significance mentioned in the preamble. So India is compromising its sovereignty in the context of global constitutionalism, or word sovereign becomes redundant, word sovereign becomes less significant in the context of global constitutionalism. So idea of global constitutionalism is effecting India's sovereign status. Is it true? While discussing in preamble, I will give you various points which support that India has not compromised its sovereignty. Or global constitutionalism has itself some limitations. There are various points which suggest that even though India is accepting global law, even though India is limiting itself in matters of passing of various laws or execution of various treaties, India is not compromising sovereignty. Sovereignty is intact. I will discuss that point. But the topic global constitutionalism is relevant. How? It is related to the idea of emergence of WTO UN's influence in the context of India signing treaties, agreements, becoming part of conventions. Okay. So global constitutionalism word is important in the context of sovereignty mentioned, sovereign word mentioned in the preamble. Same preamble. When we are going to discuss, we will discuss about the relevance of word sovereign, socialist, secular in present situation. How these words are still relevant, how they are relevant, we will discuss. Okay. So one topic we discussed constitutionalism, its features, then global constitutionalism. One more related concept in the constitutionalism is the economic constitutionalism. Okay, the idea of economic what is this word economic constitutionalism? So again, ism is a philosophy. So philosophy under which the economic framework of the constitution is restricting a government. So government's power is restricted by economic framework of a nation. So what is economic framework of our nation? So in our context there is use of word socialism. The crude meaning of socialism is the ownership of wealth and resources in the hands of state. State is the owner of all the wealth and resources. But in practice, when we are practicing socialism, the socialism means not just ownership by the state of the wealth and resources, capital, etc. It also means bridging the gap. So in practice, in a crude term, it is related to ownership. Socialism is related to ownership. But in practice, it is not just ownership, it is concerned with bridging the gap. So it is related to inclusion. So there is a rich, there is poor. Gap exists between rich and poor. If the state tries to bridge this gap, steps are taken that poor comes in the line of the rich. This is bridging the gap. This is the concept of inclusion. Inclusive growth, inclusive development, or some should not left out, bringing everyone within the domain of development, growth, etc. Inclusion, idea of socialism. So bridging the gap is one of the concept related to socialism. Not just ownership, inclusion also part of socialism. So when India is a socialist country, how India could achieve its socialist idea? Two pillars existed. This socialism was rested on two pillars. In case of India, twin pillars were there, on which the idea of socialism rested. One pillar was planning, concept of planning, planned development, planned growth, backward region, backward people, backward society, underprivileged, marginalized, they should be bringing within domain of development. Planning can help. And second was PSU. A simple example, not detailed, that PSUs were targeted to be established, created in the backward regions. Odisha, Chhattisgarh, Jharkhand, in these areas PSUs number was more. Or attempt was made by government to create PSUs there so that the very backward population, marginalized section of society could also come into domain of economic growth and development. This is the reason PSUs existed there. So PSUs will create employment, it will bring the social and economic aspects of the people into streamline. So two pillars were there, planning and PSU, by which government could achieve socialism. Now we find that government has abolished the 5-year plans and PSUs are losing their significance. The status of PSU declining and its role is now played by open market. So when open market is playing more important role, open market is trying to dominate the scene, in that case PSU becoming less relevant. Both pillars are now second and they are crumbling. So scholars say that India is heading towards a capitalist format of the economy. It is also again wrong. We will justify Indian socialism in different lecture. But how this idea is relevant? If constitution says socialist, then the country's economy should be based on that constitutional philosophy. So departure from economic constitutionalism. And suppose constitution writes capitalism, then practice socialist idea, then it is also again departure from economic constitutionalism. So economic constitutionalism has been compromised, scholars say, in the context of India shedding its character of socialist economy by rejecting 5 years plan or abolishing 5-year plans and underestimating or devaluing the role of PSUs. So what is economic constitutionalism? A philosophy under which the power of the government, authority of the government in matters of economic policy restricted or limited by economic ideas of the constitution, economic philosophy of the constitution. So in case of India, socialist pattern or socialist is a word used in the preamble. DPSP also talks about some socialist ideals. In this context, when India is departing from the concept of planning, PSU is trying to head towards a market-based economy or an open economy through WTO. It is compromised with the idea of the socialist mentioned in the preamble. From this point of view, economic constitutionalism has been compromised. Clear? So, finally, I will discuss that how it has not been compromised. But word, how economic constitutionalism word is relevant, word is significant, this I discussed in this lecture. So this lecture is not about concluding what is status of India in terms of global constitutionalism or sovereignty in terms of economic constitutionalism or compromise with the economic philosophy or ideals of the constitution. It's not about that. So we could understand, we could get the word what is constitutionalism. Second, what are the features, what are the characteristics in a state if it is following constitutionalism. Third, what is global constitutionalism. And fourth, what is economic constitutionalism. These words we discussed. Now, a related word. So, if philosophy of constitutionalism is to be practiced, if it is to be practiced, then rule of law is important. So, understanding the concept of rule of law is also needed. In this lecture, I will discuss a brief idea regarding rule of law. Detailed discussion is made somewhere else. So, let us understand what is this rule of law. Simply, rule of law means who rules, not person. Person is not ruling. Any institution is not ruling. Law is ruling. Who rules? Law is ruling. So, law is supreme. Law is above everyone. So, rule of law means law governs. People don't govern. Institution don't govern. Who governs? Law governs. Now, law can create institutions, mechanism, or give power to individuals or people to govern. But ultimately, the law will be supreme. As I said, Kautilya mentioned in his Arthashastra that king should codify law. Why? Because Kautilya also wished, he wanted that king should also rule based on law. Got the point? Now, the most popular philosophy concerning rule of law has been given by A.V. Dicey. So, to understand rule of law, we will understand A.V. Dicey's idea. A.V. Dicey is a British constitutional expert. His book, The Law of the Constitution, written as early as 1876, around that period, discuss in details about the prevalence of rule of law in England, its characteristics, its implications. So, what Dicey says, in the words of Dicey, what is rule of law? A.V. Dicey, his book, The Law of the Constitution. There are three components of rule of law. There are three elements in rule of law. Three things in rule of law. First, no one is above law. Everyone is equal. In the eyes of law. Constitution is the third point. Constitution is the product of rights. Constitution is the product of rights. Rights is same point. Rights is not the product of Constitution. What are the three elements in rule of law? No one is above law. Everyone is equal in the eyes of law. Constitution is the product of rights. Rights inverted, commas, apostrophe I have given. So rights is singular, not plural. That is why is. So rights is not the product of Constitution. Okay. What are these? He says no one is above law. Here, when he talks about law, he talks about ordinary law. Ordinary law means that the law which is applicable to citizens in general. So, you see monarchy, king is above law. Or dictatorial government. Dictators kept themselves aloof from or immune from the implications of law. So, if a dictator is killing someone, he will not be hanged. He is not given death sentence. But other people are killing someone, they can be given death sentence. So, here not about equality. First, a person is outside the framework of law. But rule of law means everyone comes under law. No one is above law. King is not above law. Any dictator is not above law. It means there is no existence of king or dictator like people in the rule of law. Okay. Now question arises, can there be monarchy having rule of law? Yeah, it's possible. In rule of law, monarchy is possible. Montesquieu, a French philosopher, he was interested in bringing constitutional monarchy in France. During French Revolution, there are three popular scholars, three popular thinkers. One is Montesquieu, second is Rousseau, third is Voltaire. So it is known that Montesquieu wanted constitutional monarchy. Montesquieu suggested separation of power. Rousseau wanted freedom. He was supporter of rights of the people more and more, and republican form of government was close to his heart. And Voltaire was against church. He wanted to demolish the church institution. So Montesquieu as a philosopher suggested constitutional monarchy. Means if there will be monarch, king, he will be working under constitution. So it is possible that rule of law existing in monarchical state system. Okay. So, but democracy can have the best practice of rule of law. In democracy, rule of law can be practiced the best. Okay. So, rule of law, according to Dicey, no one is above law. Everyone is under that ordinary law. And second, everyone is equal in the eyes of law. Everyone is equal in the eyes of law. If you look to Indian Constitution, there is Article 14. Article 14. It talks about two things. Article 14 talks about two things. Two elements are there in Article 14. What are they? Number one, in Article 14 there are two things. Number one, equality before law. Before law and equal protection of law. And you know well about it. Both components combined together bring this point. So everyone is equal in the eyes of law. There may be exception, like president cannot be tried for any criminal offence during the term of his office. Equal protection of law, equal treatment in equal circumstances. So a person is killing someone with intention to rob, to snatch something. Person can be hanged. But a person who is killing someone in order to defend himself. A robber comes, attacks the family member, one of the family member trying to save child or himself, and in that process the robber got killed. A person kills someone to save himself. He can be given 5 years imprisonment or 2 years imprisonment, or can be freed, acquitted from the murder case. Why this is possible? Because circumstances were unequal. So equal protection only in equal circumstance. So everyone is equal in the eyes of law. This format, not just equality, crude equality, universal application of something irrespective of a circumstance. It should not be there, but everyone is equal with respect to Article 14 mentioned in our Constitution. 2 points. No one is above law, everyone is equal in the eyes of law. And third one, Constitution is the product of rights. Right is not the product of Constitution. basically idea comes from various scholars' work, especially John Locke's idea, who talks about natural right philosophy. There is an emergence of natural right, concept of natural right. And natural right, one of the thinker, John Locke, says that right is there because human being takes birth as human being. Right is not there because constitution is there. Right is not there because law is there. Even if constitution is not there, right is there. A child takes birth as human, so he has some rights. Like Rousseau says, man is born free. Freedom is fundamental to human being. But everywhere he is in chains. So natural right says that constitution exists or not, it does not matter, right will be there. Law is there or not there, right will be there. Society is there or not there, right will be there. Government is there or not there, right will be there. Right is there, irrespective of everything. This is natural right philosophy. Okay, so right does not come from constitution. And that is why America, Thomas Jefferson, when bringing amendment to American Constitution and Bill of Rights was introduced, first 10 amendments. Then he says, he writes in the amendment part, and even today in American Constitution this part exists, that right which is not provided by this part also available. So right mentioned in the Constitution, right not mentioned in the Constitution, all are available to people. That means right is not because of Constitution, Constitution is because of right. India had limited, Indian right had limited repercussions. In this context, A.V. Dicey's rule of law was not fitting here. Because fundamental right, just mentioned in part 3, fundamental right. Beyond part 3, like right to vote, or Article 326, or right to property, which was their fundamental right, now constitutional right, Article 300A. So right which is only in part 3, they are the rights of the people as fundamental right. Other rights are not so fundamental that you can approach Supreme Court under Article 32 to protect it. But Supreme Court itself in its judgment, if you look at the Supreme Court judgment, Menka Gandhi case and later on judgments, 1978, Supreme Court took away from Parliament the unlimited power to legislate on the rights. So Article 21, which says right to life and personal liberty cannot be denied except without procedure established by law. Means Parliament can pass a procedure to take away right to life of the people. So Parliament passed the law that people can be imprisoned, personal liberty taken away, or people can be hanged to death. But court in Menka Gandhi case said that this power of Parliament is not unlimited. Reasonableness must be there. It should be just, it should be reasonable. So a person is suppose stealing a burger. A child is stealing a burger. You can't hang him. You can't pass a law that child can be hanged. So there must be some reasonable context of law. It should be just, it should not be arbitrary. So court tried to restrict Parliament's power. Plus, from 1978 onwards, we see a trend that court had tried to bring other rights into the domain of fundamental right. Like court talked about right to education, right to privacy, right to development, right against handcuffing, right to speedy trial. Various rights court talks about, which is not mentioned in the Constitution, but it linked with Article 21 or other respective articles. So we see a trend that even though as per Constitution the right is the product of the Constitution, but court has tried to explain it in the context of natural right philosophy, that even if rights are not there in the constitution, it can be made available to people, it should be made available to people. So Supreme Court in a various judgment had tried to restore A.V. Dicey's idea, point number 3, that constitution is the product of right, right is not the product of constitution. So 3 prominent philosophies are there, points are, elements are there in rule of law. And if these 3 points are there, you can say philosophy of constitutionalism is followed, is practiced. Especially the first 2 points are very important. It helps in restriction of the state's power. State's unlimited power is restricted. Even third point too helps in restricting the unlimited power of the state. What the point? So it is about rule of law. In different lectures I will talk about its implication, how rule of law is interrelated to other philosophies, other concepts, other ideas. But the basic idea, I think you have come to know. So this is the one basic lecture concerning constitutionalism, rule of law, some of the minute dimensions of these 2 concepts. They are complex ideas. So I have tried to explain it. In one of the lectures, I will discuss how rule of law or constitutionalism related to natural justice, separation of power, or some other philosophies concerning the political system. Okay. So any query you can drop me one WhatsApp message, I will reply. Thank you very much.